Hey, good Saturday afternoon. Carl Rominger here with Weekend Appointment, show where we answer your legal questions. 540-0580. That's my talk line, folks. 540-0580. Call in. Give me your question. I'll give you an answer on the air if we can. Sometimes we can't answer it. Sometimes we need information that you shouldn't disclose on the air. And, of course, as always, don't use real names in terms of, who you want to sue, who you want to divorce. And I can't promise you that your spouse isn't at the mall listening to the show if you want to ask a divorce question and wouldn't recognize your voice. 540-0580. And, of course, remember, go to Weekend Appointment throughout the week. Post questions. I'm going to answer some of those today. And I will be taking a few of those on the air. But we already have a caller, so 540-0580. Charles, you're on WHP 580 with Carl Rominger.
Yes, sir, Mr. Rominger. I had got, about 9 days ago, someone stole a cell phone out of my house that my daughter let in. And now it was like a $30 cell phone, but now I get a subpoena in a criminal summary case from a district justice, and it says event preliminary hearing, Dauphin County Prison. Do I have to go to it, or can I, drop it, or what?
Well, I guess what you're asking is somebody robbed somebody or stole something from your house, and you're being subpoenaed as a witness in the case, correct?
Well, it was mine. I'm the one that called the police.
Okay. The answer there is you should go, and there's two reasons why. One is you have a court order. That a subpoena really is just a court order requiring your attendance. So unless the judge or the prosecutor, the person who issued the subpoena, excuses you,
right,
you do have a legal obligation to go. Number two, though, you called the police got involved, and they just want a little follow-through from you. And I don't think that's too much to ask.
My thing is transportation problems and losing a day at work.
Understand that. And you know what I would do? I would call the court, if I were you, and ask the district justice who issued the subpoena, tell them what your situation is. They may be able to move the hearing to accommodate you because you were the victim in this matter.
Oh, okay.
But you do have to obey a subpoena because you could get yourself in trouble, okay?
Okay. Yeah.
I don't want that to happen.
Yeah, me either. But I have another question for you, too.
Sure.
How I know he stole my phone, I couldn't go on the internet and see the phone calls he made, and I wrote it on a piece of paper, all the calls and stuff, proving he did it, and the cops came. They didn't even want to see that information.
Well,
I don't know how to prove that he took it.
Well, probably at some point they must have found the phone in his possession, or they tracked it down somehow, because obviously they were able to charge him.
Oh, no, he's in jail on another charge that he got for stealing BlackBerries.
Okay, well, that's they were already on to him.
Right.
All right, Charles, good luck with that. Always honor your subpoena, okay?
Yes, sir.
All right. Folks, talk line numbers 540-0580. Carl Rominger here. This is a show where we answer your legal questions. I want to take one from the internet here. I had one about home ownership, which is pretty interesting. Somebody said, I got married to someone who owns their own house. I am in his will as the primary beneficiary. Should we get the title registered in both our names, or does it matter? And by title, I think they mean the deed. Concerned if he passes away, I will not own the house. That's true. You're going to have to open an estate, and you're going to have to transfer the house. But if you jointly titled it, and I put the answer here on the internet at weekendappointment.com, if you jointly titled the house, it would automatically pass to you on death. So if that's truly your intent, get the deed done. That's only going to cost you the filing fee. There's no tax to transfer from husband to husband and wife on a one-time transaction like that. So you don't have any other reason not to do it, okay? And also, if your husband were to change his will at some point and write you out, then you might not have a claim to the home at all, or at least only a portion of the value of the home to take against the will. So I would recommend you do, in fact, if you're in a married situation and your intent is for the spouse to take the house at death rather than just use a will. Also, you get an additional protection. An asset that is jointly titled to husband and wife cannot be reached by creditors or judgments that are only against one spouse and not both. So keep that in mind. Scott, you're on WHP 580. My talk line number is 540-0580. What's your question, Scott?
Hey, good. I'm an owner of a small distribution company.
Okay.
And we have an account that is closed up shop, so to speak. And they owe us a substantial amount of money.
Okay.
Now, I know that the one of the owners has built within the last year a home in Florida, and essentially he's used. There's several of us distributors that they've smacked for a decent amount of money, it's almost like I feel like they've taken our product, not paid us for it, and he built his house. Now he's closed shop.
Right.
Now the shop was incorporated. Is there any way I can go after him personally or not?
Well, two things. Number one, and I don't know if you did this or not, but whenever you're dealing with a small business that's a corporate entity, always get the person who's the principal owner to sign and agree to guarantee the corporation's obligations personally. Now,
we have that. In our.
In your agreement with him?
Yeah, but no, he didn't. He did not sign the personal guarantee.
Right. And if he didn't sign the personal guarantee, then your only action is against the corporation, and you'd have to pierce the corporate veil. Now, if you can show actual fraud or something along those lines, you might be able to do that.
Okay, good. Essentially, there's three. I know there's two other distributors in front of me. And
right.
Dollar value, and between all of it, it's in excess of probably $140,000.
And if any of the product's still there, you may have an action called replevin, which is an action to secure your product and seek its return. If you think any of it's still in there.
Going and been installed in people's houses.
Right, right. Short answer is it might be worth exploring for that amount of money, and also keep an eye if the corporation files a bankruptcy. You might want to try to get in line on that. But it sounds like you're going to have to show some kind of either fraud by the corporate owner and conversion of the product, but probably without that personal guarantee, your legal rights are a little nebulous here.
Yeah, so, basically I'm out.
Yeah, that's probably the answer, but I wouldn't discourage you from sitting down with your personal counsel and having them look it over real quick just to make sure there's not some claim you could bring against this person. Problem is you may not know or be able to show off the top of your head what they did or didn't do in terms of internal fraud. I mean, if they kept good corporate books or not, for instance. You may be able to pierce the corporate veil, and if you can, you could get him individually.
It just the guy built a brand new house, down in the Florida Keys, right on the beach and all that, and then he's sticking all the...
Yeah, so you might want to try to reach through that corporate veil and reach the individual, and maybe you want to get maybe you guys want to pool your resources on that.
Yeah, I don't think the other distributors know that.
Okay.
Okay, well, thanks.
All right, man. Thanks, Scott. Take care. Well, folks, that's it. When you're in business, get them to sign that personal guarantee. If you're going to do business with Nathan Incorporated, make sure that Nathan, the individual, signs. Terry, you're on WHP 580 with Carl Rominger.
Hi. I have a question regarding billing of medical insurance.
Okay.
Recently, I found out that when you go to my doctor's office, you can't just call in and get your routine prescriptions refilled anymore. You have to make what's called a medical management appointment, and they charge you an office visit for a nurse to come in and look at the pill bottles and write the prescriptions, and then a doctor signs them. But they charge you a $20 office visit for this. Now, is that legal, or is that insurance fraud?
Well, I don't think it's either. The answer is if the insurance company wants to be certain that by refilling your prescriptions, that they know what you're on, what you're doing, that you've actually taken the pills, etc. I'm not certain that there's no right to health care. I mean, unless you're Obama, there's no right to it. Yeah. So if you think about it that way, I mean, they're just billing you for a service, and they're saying we're only going to provide these prescription updates under these conditions. And I think the idea there is to make sure that your medicines are necessary and being properly used.
Mm-hmm. Okay, because they don't even discuss them with you; they just
write them down and look at them.
Yeah.
And Terry, I don't know enough about why they're doing that. What the policy reason is? I'd be curious to find out why. There must be some reason they're doing it, because it costs, even though they're charging you $20, it costs more than $20 to send somebody out there.
Yeah.
So I'm sure they're not doing it for no reason at all.
Mm-hmm. Okay, because they're the only office in the area
that takes your insurance.
That does that.
Yeah, I don't know. I do not know.
All right.
Okay,
thank you.
Good luck. I don't know. It seems to me the doctor's office and the insurance company aren't going to make extra work. I mean, it's not, the insurance company doesn't want to pay the doctor. And so the insurance company isn't going to have the doctor do anything that costs the insurance company more money in the long run. So I'm not sure what the answer there is. Bob, can you hold with me through my break?
Yes.
All right, Bob, hold on. We're going to go to break right now. 540-0580. We're going to talk to Bob after the break and you. 540-0580. Hey, welcome back. Carl Rominger here answering your legal questions. I got Bob on hold. 540-0580. 540-0580. If you have a legal question, you call in now. We'll answer it on the air. Throughout the week, you need to get a hold of me in my office. You got a legal problem you want to post on the internet, you go to weekendappointment.com. You can post your question there. You can email me from there, and you can call me from there. Oh, that crazy Shane. Bob, you're on WHP 580.
Hello.
Yeah, Bob.
Okay, I'm a physician, and I might be able to shed a little bit of light on the lady's question before the break.
Awesome.
And basically, the reason you give a prescription that doesn't have, that doesn't go gratuity, that's for 3 months, a year, whatever, is because you need to see the person again. Things change. If the person's very stable, you might give prescriptions out for a year. If they're not as stable or it's a potentially more dangerous drug, you might only give one out for 3 months. But the purpose isn't to just call in because you didn't want to write, 60 instead of 30 on the prescription. It's because that's the point at which you want to reevaluate the patient, make sure they're doing okay, make sure the drug is doing what you want it to do,
right,
and not doing things you don't want it to do. And that's the whole idea behind that, is that you want to keep in touch with the patient and make sure things are happening the way they ought to be happening. And so basically what she's complaining about, I guess, is that she can't just get her prescription refilled, and you're saying, that's a great idea, except that I'd like to look at you and make sure you're not jaundice or anything before I fry the rest of your liver. Exactly. As a matter of fact, we amongst the medical community often comment kind of a little disparagingly about doctors we see, because we'll see the patient and maybe having a problem in an acute care setting, and it's like, well, when did you see your doctor last? Oh, 2 years ago. I said, well, who's writing this stuff? Oh, I just call in and they call in another prescription form. Like, holy cow,
Right. Right.
So, no, there's a very good reason for that.
Yeah. Did you have anything else you wanted to tell us, or that you just helping us out with that?
No, just happened to hear that, and I wanted to make sure everybody understood what the concept was there.
Bob, I really appreciate it. Thank you very much. That's what I love about the radio, is a lot of times we have a question, and there's always somebody out there who knows a little more, and I encourage anybody who's got an inside line on anything we talk about, another lawyer, doctor, machinist, whatever, gun dealer, whatever you know about we're talking about, call on in. Thanks again, Bob.
Have a good day.
You too. Let's see who we got here. Who's next? Jim, you're on WHP 580.
Hi, Carl.
Hey, what's going on?
How are you?
Good.
My question is concerning prenups. I've heard different things from different people. I'm just interested in how binding they truly are.
Oh, well, a prenuptial agreement, the fancy word for them is annunuptial agreements, are in fact binding in Pennsylvania. However, there has to be a couple things. First of all, they have to be knowingly, intelligently, and voluntarily entered into. And so our courts have said that where the bride is presented with, and I assume it would apply to the groom as well, is presented with the agreement an hour before the wedding, a day before the wedding, that's probably not fair to them because the family's already there, et cetera. And so we're not going to make them enforceable. So I would tell most clients you want to be a month ahead of the wedding to prevent any kind of claim of duress there. Number two is whether they had counsel or adequate counsel. And so you almost always want both sides to have their own separate lawyers so that the agreement can't be attacked for lack of, again, knowing, intelligent, and voluntary. I didn't have sufficient legal understanding. And the number one most famous way to void an annunuptial agreement is to show fraud in the disclosure. And you're supposed to disclose all your assets to each other in an annunuptial agreement. And I can think of a case where a fella forgot to disclose that he owned a golf course. Now, as you can imagine, his wealth was such that the wife obviously didn't know or didn't look at this guy's income or checkbook and know whether he had a golf course or didn't have a golf course. So he must have had some wealth. But nonetheless, the failure to disclose an asset voided out the antenuptial agreement because the court said she didn't know what she was giving up when she married him. And so there has to be full disclosure from both sides. So if you get all three of those things, which is, no duress, knowing, intelligent, and voluntary, and full disclosure, they're generally enforceable. Now, the next thing a lawyer will tell you is, okay, but I'm still a little nervous that some judge may find this unfair someday. So we like ones that also include provisions for maintenance and care beyond divorce. So, for instance, if you have a really wealthy person, you might want to include in there that says, for every year we're married, I'll pay you $200 a month in indefinite alimony. So if we get divorced after 15 years, there'll be $3,000 a month there for you, or something along those lines. So those kinds of provisions are liked as well. Does that make sense?
Yes, it does. I was interested to see if before you're married, if they can claim, in other words, if you marry a person after you're retired,
right?
Second marriage, they cannot claim your retirement. Is that true?
Your retirement is not a marital asset at that point because you brought it to the marriage. However, it does count as an asset for distribution purposes when we start to look at what you should get out of the marriage or shouldn't get out of the marriage. We'll go ahead and say, okay, you have this non-marital asset on your side of the pot. So when we're dividing up, say, the house you bought together, we might give the other spouse more of that house because you have that non-marital asset that can't be reached.
Okay.
So an antenuptial or prenuptial agreement is always a good idea for people who already have property and who are concerned. The other place it's helpful is with the kids. A lot of times the people who come to me to get prenuptial agreements done are not young people. They are, in their 50s, retired. Each one has 2 kids from a different marriage, and they just want their kids to be sure that it's a marriage of love. And they actually share that with the kids. Yeah, we signed a prenup so that you guys don't worry about your inheritance, and that I don't want to hear that she's or he's here to take your inheritance because they're not going to get it.
Okay.
All right?
That's a big help. Thanks a lot, Carl.
All right, man. Thank you.
Mm-hmm.
Let's see, I'm going to take another caller here. But first, I want to give everybody a heads up. There's an organization out there called Angels for Alyssa, and they're seeking a cure for methylmalonic acidemia. And they have a Saturday, the 5th of September, a concert coming up, family concert with Cheap Sneakers and the Love Haters, and that's going to be the Mechanicsburg Club Picnic Grounds. And I've posted that on weekendappointment.com. I'm going to be there. It's a great event. It's for a good cause, and I strongly encourage you to check it out. You can go to Angels for Alyssa, ALYSSA.com, or just go to weekendappointment.com, go into the announcement section. And as always, if you have an organization or something you want up there, let me know. Ron, you're on WHP 580 with Carl Rominger.
Hi, Carl. How are you today?
Good, Ron. What's going on?
I really enjoy your show, and I just got a question. I saw where the appointment with Sotomayor
Yes.
Taylor got her the Supreme Court position. It's true, right?
Yes, she is on. She was sworn in.
I have a question. I hear from both sides of the political aisle going into this appointment process, things about her. And my question is there some place in the Constitution that clearly and in simple language delineates what the responsibility of a Supreme Court justice or any judge is?
No.
That's why the controversy.
They're called Article 3. I mean, it's Article 3, right?
Okay.
I'm pretty sure it's Article 3. It's been a while, but the long answer is that was one of the first things or big questions was when John Marshall, I believe, made one of the first decisions of the Supreme Court was as Mayberry versus Madison or Marbury versus Madison, and the question was, what is our job here? Because the president had appointed somebody, and then the next president kind of pocketed that because it hadn't been officially put through yet, and he sued to enforce it. And the question was, what were the powers of the Supreme Court? And early on, John Marshall took a John Marshall J. I don't know. Anyhow, he took a strong stance on it and said, yeah, we have the ability to review the actions and check for the constitutionality of things, and it's been that way ever since.
Okay, I wondered because, the controversy always comes up. Is the judge's job to rule on the law or to do what they think is right?
Yeah.
And I think conservatives tend to think, no, they're supposed to rule on the law, and liberals tend to think, well, that's one thing, but also, what they think is right and good.
Right.
And I always thought that, well, if it's not right, if the judge thinks it's not right and good, isn't that the job of the legislature to change the law to make it?
Yeah, and in fact, Ron, let me tell you something. This whole thing about, a judge is supposed to just be a referee. That's all he's supposed to be, on the conservative side, versus the judge is supposed to create the law. They're both wrong. And what I mean by that is the reality of it is judges have to interpret stuff. And sometimes in interpreting, you create because, what does reasonable search and seizure mean? Well, if I'm just a referee, I don't know how does a referee decide what's reasonable or not reasonable without applying some discretion to the question. And so I'll give you an example. The game of golf, when I hit a golf ball and it lands in a hazard, the rules say, where you're reasonably certain or you've reason to believe the ball crossed into the hazard is the appropriate drop point. You don't have to be exact. You have some discretion there. And if there's a group of people there, trying to figure it out, you go, well, it looked like it came across the hazard here. You have to use some discretion. And so the four guys in the foursome or the four gals kind of all put their heads together and go, Bob, I think it's right over there. That's where you should drop your ball. And there's some interpretation going on there. Well, it's the same in the law. We have to look at what is reasonable or unreasonable for searches and seizures, for instance. And so how can you be a referee when the question is what's reasonable? Where do you draw from? I mean, the Constitution doesn't have an exact definition of what that is. And if you were a referee and you had an exact definition, it's 3.5 foot from the first red stake, well, then you would know that's where it has to be. But otherwise, where it's discretionary, which is most of our Constitution, it's not so clear. You can't just be a referee. So both sides are a little misleading when they argue it that way. Ron, I got to go into break. If you want to hang across the break and talk a little bit more about this?
I probably don't have time to.
All right, Ron, I'm going to let you go.
I may call back sometime because there's a couple of more things I just want to ask related to it.
I would love to talk about that some more. All right, Ron, thanks. 540-0580. 540-0580 is a talk line number. When we come back from the break, we'll answer your legal questions. There's the music, and I am joined in studio today. I have in my studio today my nephew Nathan and my niece Madeline. You guys want to say hello to everybody out there? Hey.
Hi.
And they're down from Buffalo, and we actually went to the Fish and Game Club shooting this morning. Nathan shot sporting clays, and Madeline cheered him on. So if anybody has any questions they want to ask some young people, we'll be happy to let them field it for you. All right, let's see here. I turned off the wrong microphone because I don't really know what I'm doing. Jenny, you're on WHP 580 with Carl Rominger.
Did you say Jenny?
Yes, Jenny.
Oh, Attorney Rominger. And hi, Nathan and Madeline. I have a question. I'm trying to get information, at least basic information, for an elderly friend of ours who is a widow.
Okay.
Her husband and she grew up with parents who apparently were born just before the Great Depression, and they were raised with the thoughts that you do not trust banks, and they've passed this along to both the husband and wife that we knew.
Okay.
And she's a widow now, and she just told us recently, I guess she's getting concerned. She said, my husband and I worked all those years, and she said we paid our bills, and we saved every penny other than that we could, and I have it all right here in my house. And from what she said, it must be around $50,000 to $60,000.
Right.
Well, we hit the ceiling and told her all the reasons why this was a very bad idea. And she says, well, I'm starting to think, with all the break-ins and maybe a fire. So she says to us, well, what can I do with that money? If I go to the bank or try to buy a CD, they'll want to know where I got it. And if I buy anything for more than $10,000, they're going to investigate me. And how do I prove that we earned this and so forth? So I just need something basic to tell her, to reassure her there's probably something she can do and it'll be safe.
Well, yeah, you can't, first of all, you can't structure a transaction to avoid that reporting requirement. Mm-hmm. So she couldn't just go deposit $2,000, because that's a crime all by itself. Yeah. To structure it to avoid that. That said, it's it's nothing bad's going to happen to her. See, you are actually allowed to have saved up cash and then deposit it. The reason the government gets concerned is they want to keep track of that. And at some point, the IRS could potentially, it gets sent off to the IRS could potentially say, hey, where did you get that money? Well, I'm X years old. We saved up our money over all the years. We're old school, and I was finally convinced to deposit it in the bank. And the burden would be on the government at that point to prove that that's not what happened, which is simply not something they're going to be able to prove. Mm-hmm. So she has nothing to fear, but fear itself, I guess, to borrow a phrase. So she should not worry about that. In fact, the fact that it's reported to the government is of little moment. What the government's most interested in cases like that is just knowing about large amounts of money that move around, so that if they see repeated transactions involving the same individual that don't make sense, or a situation where, she deposits $582,000, is that some kind of ransom, or what's going on?
Well, in other words, then she could go to her bank and take out CDs.
Yeah.
And how often could she do that?
Well, she could do it whenever she wanted.
For the whole amount. Yeah,
absolutely. But here's the thing. What I would strongly recommend her to do is consider going to a financial advisor.
Well, that's what I mentioned to her, and I said, let me see what I can find out if I could get through to you, and then I would tell her. Yeah,
I would strongly recommend she see a financial advisor, because CDs are one way to go, and there's ways to set that up. But there may be other products, including types of annuities, which would be better for her, because I don't know how old she is, but if that's her life savings, she needs to work it into not only money that she could tap, but into an income stream potentially.
I think she's about 87.
Yeah. Yeah, well, you know what? There are people today that are about 107 too, so she still needs the plan.
Well, listen, I'm sure that'll reassure her, and we were just glad that she did suddenly start to worry about this. So I'll give her that information, and I'll let her take it from there.
All right, Jenny, thank you very much. She's lucky to have a friend like you.
Oh, thank you.
All right, take good care of her. Well, folks, you can take money into the bank and deposit it. Obviously, they're going to want to know where it came from for purposes of filling out the form. But it doesn't mean that the government's going to suddenly swoop down and say, oh, my gosh, you stole it. Oh, my gosh, you didn't. Obviously, if you did steal it, you might have a problem. Or obviously, if you're involved in some kind of cash business like the drug trade. But you'd be surprised. All the IRS cares about is if you pay your taxes. So there are lots of people in the United States who file tax returns every year, and on that little area where it says, how did you make this money, they just leave it blank because there's a policy interest in collecting the tax. And so organized crime and other people like that quite often pay taxes, and the IRS doesn't report that out to anybody. That's the same reason why the IRS went down to Arizona. And by the way, the talk line number is 540-0580, 540-0580. If you remember, the Arizona sheriffs out there who go crazy about illegal immigrants all the time went and got some tax records with a warrant because they were sure that this Hispanic tax preparer was doing taxes for illegal aliens, which I'm sure they were right. And they wanted to go through the records and spot the illegal aliens and deport them. And the IRS swooped in, and the federal government said, whoa, what are you doing? What are you doing? We want illegal aliens to file taxes because they file their taxes, they pay their taxes, and we get to keep the money. If we take them off the books entirely, then we don't get the money. So there are policy interests in that. So the government really just wants to know where the money came from, and if it's not a taxable transaction, they're not going to care about it. Obviously, she keeps going back with $50,000 every month in cash, and she keeps claiming it was under the mattress. I think after a point, they're going to question her on that. Again, 540-0580, 540-0580. For those of you just joining us, this is Weekend Appointment, the show where I answer your legal questions on the air. We also have weekendappointment.com. And I want to remind you to go to the website throughout the week and get my contact information. If you need to hire me or one of my associates, we're happy to help you. You go to weekendappointment.com. We also have free wills available. If you go and you become a registered user, you can go to the registered user area. You can download a will form, which you send in and get a real live lawyer to write you a real will. And so I strongly recommend you do that. I did get an interesting question on the internet. My son has signed a 1-year lease in a home that is currently 2 apartments. The landlord has advised my son that the property is up for sale, but tells my son that if the house is sold as a rental property, his lease will be continued with the new owner for the length of the lease. Is there any legal basis for this? Well, the answer is yes. A lease is just a contract, and it can be assignable. Now, some leases have a non-assignability clause in them, and some are expressly assignable. And I think lacking an assignability clause, addressing it either way, it's probably assignable. And that means you can sell it to somebody else. Usually people who buy commercial properties want it to come with a tenant. So the fact that you can assign those leases or keep those leases is to the advantage of the new buyer. Now, conversely, interestingly, absent a recorded lease and one that's a little more ironclad, if the property is sold for a new use, besides rental property, for instance, then the lease could be broken by the landlord or the new buyer. Kevin, you're on WHP 580 with Carl Rominger.
Hello.
Hey, Kevin, you're on the air.
How you doing?
Good, man. What's going on?
Hey, I really enjoyed this morning, just running into you shooting sporting clays and everything, but my question is not really a legal question. What kind of cigar were you smoking, and how did you select that specific cigar?
I was smoking a Perdomo, and a rather robust one, because my sister-in-law and my brother are not smokers, so I want to make sure I had a particularly strong and odorous cigar as we walked around through the woods. But I like a strong cigar.
Yeah, that's good. Now, can I ask Nathan a question?
Yeah, let's see. Let's Nathan. I think I got his mic on. Go ahead.
Hey, Nathan, what do you think about your uncle smoking?
It doesn't really matter to me, as long as I don't have to stay in this cigar club for long periods of time.
All right, but what do you think about the shotgun he was shooting? You did all right with it today. You like that one?
Yeah, I like that shotgun. I'm used to it.
Yeah, he's used that a few times now.
Yeah, you think you'll get one like that someday?
I think his parents are saving up for it, along with his college fund.
Oh, that's a good idea.
Actually, he's going to do a little work for me on the side with his computer at home, so maybe we'll just make him save up that way.
Yeah, I think you should take him sometime in September when you get out there.
We're gonna go do some. Actually, he'll be old enough to hunt deer in New York for the first time this year, so we're gonna go out deer hunting.
Great. Well, good luck and enjoy the show.
Hey, thanks, Kevin.
Sure, bye.
Thanks.
Let's see here. Well, that was a personal call. Bill, you're on WHP 580 with Carl Rominger.
Yes.
What's your question, Bill?
Yeah, my question is, I made my own last will and testament, and I'm dividing everything half between my son and my daughter, and I have a college fund for my grandson.
Yeah.
Do I need to get this notarized? Should I have it notarized?
You don't need to have a will notarized in Pennsylvania. I mean,
okay.
all a notary does, unless it's statutorily required somewhere, all a notary does is show us that you are actually the person who signed it. So if somebody were to contest your signature,
correct,
the notary stamp would help prove it is, in fact, you.
Okay. Well, then my last will and testament, last question is, I have it with my banking, my advisors, and they told me to make it up, so they said they'll stick it with it, and then they'll see that everything is carried out. So
right.
I guess that's okay then, right?
That is. Now, if you appoint them as the executor or executrix in that, they will charge a fee. A lot of times what we do is just have the kids become the executor or executrix in name, and then that way they don't get administrative fees and legal fees. That way they just get legal fees.
Okay. Well, I have my brother's daughter is one, and then if she's not able to, then I have my former wife.
Gotcha. So. Now, of course, I have to tell you is, without seeing what you've written up or how you've written it or what you based it on, I strongly always recommend you use a lawyer for a will. And, of course, since we do free wills on weekendappointment.com, the cost is very reasonable.
Okay. What is your email then?
It's just go to weekendappointment.com, and you can email me right off there.
I'll do that then, okay?
All right. Thank you.
Thanks a lot. God bless you too.
No problem. Folks, I got to go to break, but when we get back from break, we're going to talk with Sally. Hey, welcome back. Carl Rominger here. Talk line numbers 540-0580, 540-0580. In case anybody cares, we're all going to Gettysburg later tonight. We're going to see the battlefields and have a dinner down there. Sally, you're on WHP 580. Sally.
Yes.
You're on the air.
Hello, Carl.
Hey, how are you?
I'm fine. Thanks for taking my call.
No problem. What's your question?
Well, about 3 years ago, my son did divorce papers, but his wife refused to sign them.
Okay.
So he wasn't there with them for a while, but then he was back in the house because he has two small kids.
Okay.
And he wanted to try to make it work out. Well, it doesn't seem to be working out. But the question is, I guess, are the papers he did for the divorce still okay, or does he have to go through all that all over again,
Well, it depends. If anybody withdrew or discontinued the divorce, then we need a new set. If the court dismissed it for inactivity because too much time had passed and nothing had gone on with the docket, then we need to file a new one. If on the other hand, if it's still a live suit, which is something we could very easily figure out, then the divorce could be completed on it. But if one of the parties was unwilling, we would probably count the 2 years from when they reunited and then separated again rather than from the date of filing, because we would say that they had reconsummated or at least attempted to reconsummate the marriage. So all we need to do is go to the courthouse and take a look and see what's going on with that paperwork. And if they both want to be divorced, it's fairly simple. If only one of them wants to be divorced, it might be a little more complicated.
Okay, but was he supposed to wait 2 years? Is that what it was, a 2-year wait?
Well, yeah, but if they lived together for a while, then we reset that 2-year wait.
And okay, so then, but now she would agree, there would be no problem,
Right. If they both agree, then they can agree at any time. They just have to wait 90 days from when the divorce is filed. So if that divorce is still open, they're good there. Otherwise, they'd have to file again, and then they'd have another 90-day waiting period in case they change their minds yet again.
How long do we know how long it's open? I mean, is there a
Well, we'd have to check at the courthouse and see what happened with it.
Oh, I see. Okay. Okay. Well, my husband's just saying that he went back because of the kids, and there's really no marriage.
Yeah, but that's irrelevant as to the legal issue here.
Okay.
I'm mixed up. And so if he might have to file again for a divorce and wait another 2 years, is that...
No. If they're both agreeing to be divorced, they have to wait 90 days from the time they file the new divorce action.
But suppose you don't want to sign it.
Well, if she doesn't want to sign it, then the 2 years starts from when they separated again.
Oh. And separate, you have to be out of the house for that time.
Well, that's a legal question. In other words, you can be separated but living in the same house. It's a factual question for the judge if there's a dispute over it.
The judge would do. Okay, I got you. Okay.
All right. Good luck.
Where are you located with your office?
We're in Carlisle, but we handle all the mid-state. I spend time in Lancaster, York, Franklin County, Perry County, Juniata County, Berks County. I go all over.
And not Harrisburg.
Well, yeah, Harrisburg, too. I almost forgot about Harrisburg. I'm in Harrisburg right now.
Oh, well, that's where we are. That's where I was wondering. You don't have an office in Harrisburg?
Our primary office is in Carlisle. We have a place in Mechanicsburg we can meet with you as well.
Okay, all right. Do you have a number to your office or anything?
Yeah, it's 241-6070, 241-6070, or go to weekendappointment.com.
I just missed that number. I'm sorry. What was the number?
241-6070.
Okay, I got it, Carl.
All right.
Hey, thanks for your time. I appreciate it.
Thank you. Sally, go to weekendappointment.com. Dan, you're on WHP 580 with Carl Rominger.
I got a quick question for you. My son is purchasing a house, and he has a girlfriend that's planning on moving in with him. Now, everything in the purchase is going to be in his name, all the down payment, all the closing costs, everything. He's going to pay it all. She's not paying any of it. But at some point, if things don't work out with these two, does she have any claim to that house then? If she helps to pay, like, electric or any of that kind of stuff?
Well, okay, girlfriend, he's buying the house.
Completely. He's paying everything.
He's paying everything. And she's just going to reside there.
Right.
As a tenant.
Well, he's not going to charge her rent, but
right.
She can help with the electric and food and that kind of stuff.
Right. Short answer is probably not. Long answer is obviously the parties are free to develop any kind of contract or agreement between the two of them that they want. And absent a written understanding of some sort, either side's free to interpret that any way they want. So a court would have to be convinced, what their agreement was or wasn't at some point. So I would tell you as a general rule, she probably wouldn't end up with any equity in the house, but could she make a claim and potentially prevail? Yeah, but it depends on how everything's done.
What would be the best way to make sure that doesn't happen?
The best way to do it would be just to sign a little agreement between the two of them that says that he owns the house and that in exchange for being able to stay there, she's going to agree to pay some of the household expenses in lieu of rent.
Okay.
That makes sense?
That sounds good.
All right, man.
Hey, thank you.
Hey, no problem. Yeah, folks, that's a huge area of law, which is unmarried couples and how to disentangle their entanglements, because we run into situations where people, they're both on the deed or one's only on the deed, but both are on the mortgage, and one bought a car, but he doesn't drive that car. She drives that car, but their mother bought the other car, and yada, 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 and you try to sort it all out. And the divorce law gives us this neat, clean set of tools for doing that. The non-divorce law, i.e. law of partnership and contract, requires a lot of factual determinations, which are usually up in the air because when unmarried couples usually get together, they don't have writings to describe what their intents are ahead of time. So be careful of that. 540-0580, 540-0580 is the talk line number. I had a question, and it's actually I thought this was kind of amusing because somebody was upset because there was a photograph of their home or garage without permission. It was published in a newspaper without their knowledge ahead of time. They're saying, is it legal to take someone else's picture of their property without their permission? Well, the answer is if your property is visible to the public, then no harm, no foul, unless you can show somehow that some undue suggestions being made. So, if they take a picture of your car or your house and it's clear that it's your car or your house and, the caption underneath says child molester lives here, well, that might be actionable defamation. But if you just park your car or somebody just driving by and they like the way your house looks and they take a picture of it, well, that's okay. In fact, my nephew, Nathan, who's in here the other day, he saw a very nice car that he would like to own someday. And he said, can I take a picture of it? Is that legal? And I thought it was funny that I had a question on the website around the same time, exactly the same content. Yeah, it's legal. You can anything that you leave out in public, other people can photograph. So if you don't want your photograph taken, don't go out in public. That's why, for instance, when people are at the Disney park and somebody else takes a picture and they're in the background, there's no harm that your picture showed up there. Now, if somebody uses your image for publicity or to make money, then that's a completely separate deal. Again, for those of you just joining us, Weekend Appointment, show where I answer your legal questions. I'm attorney Carl Rominger, practice throughout the mid-state. If you need to get hold of me throughout the week, use weekendappointment.com. You can find my phone number there, my email there. We have 4 attorneys in the office who can help you, and we're always honored to have people as clients. So, again, go to weekendappointment.com. And I want to remind you about those free wills. A lot of people have taken advantage of that. What you do is you go to weekendappointment.com, you register as a user, you download our will form, and you fill it out, and you send it back, and then I meet with you, and I go over your situation to make sure that the will is appropriately written for you for whatever your needs are. Some people have lots of money, some people have lots of kids, some people have neither, and some people have both. And how we handle that and how we need to look at your situation has to be made an individual determination. So if you've gone to some website and done one of these, fill out the blank will forms and printed it out, or, go to this legal Zoom or whatever that name of that website is, and you do those sorts of things, you might not be actually getting what you need or addressing things in a way that you really want to address them. And a lot of times it's not that you couldn't do it on your own, it's just that you don't know what things you need to remember. I'm always amazed when I ask people, like, well, did you want the grandkids to be able to get this? And they go, oh, yeah, I did. Hey, there's the music. That means I've got about a minute left. Somebody's calling right now, and you're not going to get through. So go to weekendappointment.com. Go to weekendappointment.com, post your legal questions, and I will see you next Saturday at 2 p.m.